Hello everyone and welcome to this video tutorial on self-defense. The basic premise of this defense is that in some circumstances it is lawful to use reasonable force in self-defense or to protect another or to prevent crime or damage to property. Therefore, self-defense really acts to negate an element of the actus reus of the crime rather than operating as a true defense. So, for example, if you think about murder, the actus reus of murder is that there has to be an unlawful killing of a reasonable person in being under the Queen's peace. Therefore, if someone uses reasonable force in self-defense and that happens to result in death of the person, that would not be murder because self-defense would make the killing lawful in those circumstances, and therefore self-defense negates that key element of the actus reus. So self-defense operates as a complete defense, which does recognize that in some circumstances it's lawful to use reasonable force. Now, self-defense is a little bit misleading as a term because self-defense allows the defendant to use reasonable force to defend himself or to prevent an attack on another person or to defend his property. And all of those rules come from common law, which means cases, but those cases have now been given statutory footing. In other words, they've actually been incorporated into a consolidating act, the Criminal Justice and Immigration Act of 2008. So this act has put all of the common law on self-defense into the act. The other situation that's also covered under the big umbrella term of self-defense is prevention of a crime. So a defendant can use reasonable force to prevent a crime. Under the Criminal Law Act, section 3.1, the Act states, a person may use such force as is reasonable in the circumstances in the prevention of crime or in effecting or assisting in the lawful arrest of offenders or suspected offenders or of persons unlawfully at large. These defences can be raised in respect of any crime which the defendant is charged with, and if successful, they result in the defendant being completely acquitted. However, if the defendant uses excessive force, that will show that he acted unreasonably and there will be no valid defence and the defendant will be liable for the crime. So let's have a look then at the requirements that we have to prove for a successful defence of self-defence. There are two requirements. Firstly, the force must be necessary, and secondly, the force must be reasonable. And as always, we'll look at each of these in turn, starting with necessary. It is essential that the force used is necessary, and this is illustrated in the case of R and Hussein and another. And you can see here that the defendant's house was broken into and he and his family were threatened by armed men. The defendant and one of his sons managed to escape and they chased the armed men as they ran from the house, and they caught the men and beat them up in the street. Now, in that situation, the defendant and his son couldn't use the defence of self-defence because all the danger from the original attack was over, and so the force was not necessary. And the court said that this actually looked like revenge. So this is showing that it must be necessary for you to use the force in that moment. If the person is retreating, i.e. these armed men were already down the street, then there is no need for you to use force. You might want to, but that will be revenge. Okay, what they should have done at that point is called the police. So it must be essential for force to be used. There's an important issue for us to consider here when deciding whether the force used was necessary, because it is possible that a defendant might mistakenly believe himself to be threatened, or he might mistakenly believe that an offence is being committed by another person when actually it isn't. And this is illustrated in the case of Williams. The facts here was that the defendant was on a bus and he was looking out the window and he mistakenly believed that a man was assaulting a young person. In actual fact, the man was an undercover police officer and he was arresting the young person. But the defendant didn't know this, and being a bit of a do-gooder, he jumps off the bus and goes and uses force on the man. He's then being prosecuted for using force on the police officer. And the defendant raised the defence of self-defence. And the court said that he was able to use self-defence even though he'd made a mistake about what was happening, because the force he used was reasonable in the circumstances that he genuinely believed to be happening. So this means that a person can use self-defense even if they've made a mistake. So if you see people who you think are arguing and about to hit each other, you might go and use force on them. If they were just having a lively chat, you can still use self-defense because the jury will judge, was the force used reasonable in the circumstances that you thought was occurring? This has now been put into Section 76 of the Criminal Justice and Immigration Act. Next case on making mistakes with self-defense is the case of Beckford. The facts of this case was that the defendant was a police officer and he was given some information that a particular person was armed and dangerous. The defendant saw a person matching this description and was terrified, feared for his own life, so the defendant shot him dead. Actually, this person fitting the description was not armed and dangerous. So our defendant had mistakenly used force. The court said self-defense can be available even where fatal or lethal force is used by mistake. So I think this case shows just how favourable the defence is to the defendant, that you can, in some circumstances, kill a person and have the defence of self-defence, as long as the force you used was reasonable in the circumstances you believe them to be. And because this police officer genuinely thought the person was armed, it was reasonable for him to fire his gun. The next case on mistakes in self-defense is the case of Taj from 2018. And this case gives us the principle that you cannot rely on a mistaken belief that was caused by being drunk. So our facts here were that Mr. Taj viciously attacked a man in the mistaken belief that he was a terrorist setting off a bomb. But it turned out that Mr. Taj, our defendant, was under the influence of alcohol and also drugs. So you are allowed to make a mistake and plead self-defense as long as it's reasonable, but not if you're drunk. We've looked at the first requirement for self-defense, that the force must be necessary, and you are able to make a mistake as long as it's not a drunken one. Let's consider the second requirement for self-defense, which is that the force used must be reasonable. A number of cases on this slide which give us some guidance on what reasonable force is. So if we start with Palmer, Lord Morris in this case felt that a jury should be directed to look at the particular facts and circumstances of the case. This is a quote from Lord Palmer in the case, and he said, quote, "A person who is being attacked should not be expected to weigh to a nicety," you need to remember that phrase, "the exact measure of his necessary defensive action." And that means that the jury have to appreciate that if you are in a situation where you're being attacked, you're not going to have time to weigh up precisely how much force is exactly proportionate. You're acting in the heat of the moment, you're acting on instinct, and the jury has to take that into account. The case of Bird tells us that there's no duty to retreat. So I think sometimes the general public think that in order to be able to plead self-defense, you need to have tried to escape first. But that's not true. In Bird, it was made clear that you don't have to retreat. The defendant can stand his ground, and that's fine. Your force can still be reasonable. The other case on this, Attorney General's reference, says that the defendant might be able to claim self-defense even where preemptive action is taken. So what that means is you don't have to wait for your attacker to throw the first punch. You can take preemptive action. You can throw the first punch if you like. So if someone's coming to me, attacking me with a knife, I don't have to wait for them to actually stab me. I might pick something up and hit them before they can touch me with the knife. Okay, and I suppose that's common sense, isn't it? So as long as the threat is clear, it's still reasonable for you to use the force first. All of these cases are showing how favourable self-defence is to the defendant. We know you're acting in the heat of the moment, so we'll bear that in mind. You don't have to retreat and you can strike the first blow. However, if the force is not reasonable and it's deemed to be excessive, the defence will fail. And this comes from the case of Clegg, where Lloyd LJ said that there's no halfway house with self-defence. So what he meant by that was it's all or nothing as a defence. If you use reasonable force, you are completely acquitted of the crime. However, if your force is excessive, you lose the defence and will be convicted of the crime. And some people say it'd be better if it operated as a partial defence if too much force was used. A key case on excessive force in self-defence is Martin Anthony from 2002. This is our defendant here. So our defendant, Tony Martin, lived alone on an isolated farm here called Bleak House. And the farm and the surrounding buildings were dilapidated, appeared to be derelict, and consequently the farm was subject to numerous break-ins. On one night in 1999, Freddie Barris, who was 16, and Brendan Fearon, who was 30, broke into the farm. Tony Martin, armed with a 12-bore shotgun, went downstairs and fired at where the disturbance came from. He then shot both intruders, killing Barris by a gunshot wound to the back. And he raised a plea of self-defense, and that was rejected by the jury, and he was convicted of murder. However, he was subsequently able to plead diminished responsibility on the grounds of his paranoid personality disorder. But if I come to this slide here, which gives us the principle from the case, this is inside his house to show you how dilapidated it was. It tells us that personality disorder can't be considered for self-defense. Tony Martin had used excessive force, and that was illustrated by the fact he basically executed a 16-year-old by shooting him several times in the back. Because the kid was retreating, it wasn't necessary, it was excessive, self-defense failed. But as I've said, he was able to plead diminished responsibility. Remarkably, the media jumped on this case and were saying it was outrageous, you should be able to defend yourself, an Englishman's home is his castle, and all of this nonsense, because self-defense has always been favourable to the defendant. But as a consequence of this case and general public reaction, we created the Crime and Courts Act 2013, or I should say the Tories did. And this allows, in householder cases, the defendant to use self-defence as long as his force was not grossly disproportionate. And I really disagree with this because I think all force should be reasonable, but this is allowing householders to use disproportionate force. This law was unsuccessfully challenged in the case of Denby Collins, where the High Court ruled that this new act is not incompatible with human rights laws, although lots of barristers, including Mendel and Wolkind, have said that this new law is a disgrace. So it's something to look at when you're doing an evaluation essay on self-defense. And I'll just end with the summary sheet, and you may want to pause the video here.